would not want to, there was endangering of human lives. And these are all articulated under the Prevention of Terrorism Act, are clear and are proper, and have been made. Under our mandate, come later, we will be able to present whatever we have so that we are able to support this count. Therefore, Your Honor, we submit that the charge be.
And Your Honor, with a bit of hindsight, and I'm quite sure, Your Honor, that no Kenyan will look at these young people and call them terrorists of the act. And, Your Honor, as a terrorist, is on conviction to imprisonment for a term not exceeding 30 years, Your Honor. And this is a person who is notice of the situation in the country, where it is already publicly pronounced that over 500 others are charging these Kenyans and others with terrorism, the offense of terrorism. Serves only the... Everything else flows out of that. We've already dealt with the matter of adequate notice and public notice everywhere. Seen on screen, some of them numberless. Your Honor, I want to advise strongly the Office of the Director of Public Prosecution. Yes. We here? Okay, please proceed.
Thank you, Your Honor. This matter is not about advice to the DPP. And I believe that once Council is acting on our mandate.
Very well.
So Council should desist and resist.
Pardon, Mr. Machira. Your Honor, whatever it is worth, I don't want to respond.
Yes, please.
Objections must be on a point of law.
Yes.
And I have not had any point of law raised.
Indeed.
Your Honor, this is the objection.
Now, yes, please. Can you
the submission by the senior counsel are intended to align
word that is uttered by the other side inflame the opposite side, and we will feel like
much obliged.
and then we will generate into an exchange of words.
Your Honor, for example, you can be charged, and therefore we invite you to agree with us that the Deputy Chair of LSP to add what I just said.
I think the Senior Counsel, whereas probably the Senior Counsel bar pertinent to law. Pertinent to law. Your Honor, at this point you will note that on the question of the village case, an initial report, it says must. It's a famous, shall any relevant documentary exhibits as a matter of caution and very important, especially on this first count, to confirm the age of the suspects as an administrative body to prosecute cases on behalf of the state. This is a power that the court regulates from time to time. And so with a lot of humility and respect, as my colleagues from the DPP are stating, we urge the court to regulate the conduct and the affairs of the Office of the Director of Public Prosecution. Now, Your Honor, if we may look at a cursory reading of the statement of facts, the persons before you cannot respond if a plea was to be taken. We have watched, as Kenyans, persons wearing the National Police uniform or insignia, vandalizing private property in the company of members of the public in Kenya. The tragedy of allowing such a charge to proceed is that even though it may be saved at the end, probably with a discontinuation or termination of the charges, prejudice will have already occurred on the persons before the court. The reading of Section 4 cannot be isolated from the definitive definition of the term terrorist act. And because we have time, limited as it is, Section 2, and I will read it, says, prejudices national security or public safety, and then proceeds to put a rider and says, and. So this charge, in the particulars, cannot be left in isolation by saying, committed a terrorist act. It has to go with the sub B, which states with an aim. Mental state, what we call mens rea, is very important because the persons before you must respond to either of the three and not all. If they had to respond to all, then in the particulars of the offense, it would have captured it that way. But, yes, that the persons before you, that the statement, the particulars of the offense cannot be read in isolation without the mental state, the mens rea, intended to do what? So that it says and, which is carried out with an aim, so it particularizes them in three. One is to intimidate or cause fear amongst members of the public. If I am too fast, Your Honor, you could ask me to slow down. Yes. Number two, intimidating or compelling the government or international organizations to do or refrain from any act. And lastly, destabilizing religious, political, constitutional, economic, or social institutions.
This is the mens rea.
Yes, yes. So that as they are responding, if they will, the court will find that they should respond. They need to respond to a charge which is holistic. It is inclusive of what they intended to do. Now, finally, what the statement of facts states, and if the court will be minded to also look at the other count 2 and count 3, they are extremely identical to count number 1, with the exclusion of the term committed a terrorist act. Now, if the court would be minded to entertain all 3 counts, before the court will be doing would be to suffer not even double jeopardy. There's something like that. A criminal law lecturer will have to revise his manual, will be triple jeopardy. Because what it says generally is that property was damaged allegedly by the persons before you. Of great importance as I sit down, and this has not been addressed, it cannot be possible to commit acts under Porter when Article 37 exists, and the court will take judicial notice that in the charge sheet falls squarely on a date that Article 37 was applicable. And that being the case, the drafters of Porter would have stopped Section 2B and not included the proviso that, I will read it for the court as it retires, provided that an act which disrupts any services and is committed in the pursuance of a protest. In fact, Porter does not use the description of the. It foresees that such protest may not be peaceful. So that, as we have seen, allegedly there was property that was destroyed or damaged, and it continues to say, demonstration or stoppage of work shall be deemed not to be a terrorist act within the meaning of the definition, so long as the act is not intended to result in any harm referred to in A1 to 4, which is the present case. On that date, materially, the court should take judicial notice that there was a countrywide demonstration pursuant to Article 37. As the court is winding up and retiring, Your Honor, we all come from different backgrounds and we all have things we do in life. I was once told by my grandmother that even a mortician has rights. For instance, those who work in mortuaries or places or funeral homes may picket and demonstrate when their workload goes down. What I mean is that when the mortality rate of Kenyans go down, Kenyans are not dying, morticians may complain. The work of the Director of Public Prosecution is not an easy one. It is akin to that of a mortician. And there are our colleagues on that side. And I changes. At one time in this country, any person who was urging, I will not talk much about it because we are being led by senior counsel, and he's my friend. It was meant to be a joke, but everyone is serious. Today, the persons before this court, the persons who are intended to be charged, but tomorrow, they may be our heroes. I urge this court as it retires with the utmost humility, because now I'm like the EPP, I mean it. count number 1, because we will come to discuss the other counts. As I had said on the question of jurisdiction, it is our position that on the second count and the third count, jurisdiction to deal with this matter under the CPC as Section 71. So these alleged offences were not committed within the precincts. Other courts which can deal. I know the DPP is itching to say that the Kikuyu court is not functioning, but there is another court nearby which can handle.
Referred to by Mr. Moi. Mr. Moi want to convince you that there are two parts of that proviso that can occasionally deemed not be terrorists act within the meaning of the definite of the referred to in paragraph A, Roman 1 and Roman 4. Roman 4 is what is of our interest. He tells you that this should be the act of protest, demonstration, or stoppage of work. That is the act which the proviso is not to the burning, destruction, or anything. It's to the action that has originated. Why am I on the street? To demonstrate. I urge you to rely on the golden rule of statute interpretation. It will not lead you to arriving to the absurdity and the mischief being actuated and perpetrated by the ODPP. The golden rule the golden rule, when it's used for interpretation, would lead you to arriving at a decision that when such an interpretation would lead to unreasonable or nonsensical results, to which the DPP is inviting you to. I rest my case.
Yes, Your Honor. See for the strong words by counsel, especially the one here about nonsensical stuff. I want to respond to that because I know that decision to charge is a very solemn decision. And a lot of repercussions. And we have taken the decision bearing in mind the response. And especially also bearing in mind the current circumstances that we are all as Kenyans are undergoing. And before I sit down, I just wish to say that there is a lot of misunderstanding on the import of the exemption.
Coming from?
Just giving him an opportunity to respond to any.
I don't think he has audience, Your Honor, with due respect, and we wish to object to that,
Yes,
because we are now reopening the case. Unfortunately, that is the rule, and the court must be bound by those rules. We can't make our own rules.
I understand.
Yes.
Your Honor, yes, I also
as much. And
understand, Your Honor.
also on the to limit as much. And when Mr. Mashira rose on his feet, I said to him, reserve anything that you want to say, and I'm not opening up for the prosecution to make any new submission.
No, yes.
And to leave it there.
You know, I am well guided, but I still insist that unless the court wants to make its own rules that governs proceedings, that this gentleman, the DPP, has no audience before you. And I would wish you to make a ruling on that, Your Honor. I make an application that will make a ruling on that.
Your Honor, with tremendous respect, the Law Society is here and we represent Mr. Ndegwa. We are asking.
Yes, Your Honor. Yes, and thank you.
Not to reopen any new issues.
Yes, thank you. Thank you to the Deputy.
Of course, we'll be making the same application
Yes.
if we can simply proceed with those two.
Indeed, I think even for the time.
And in those two, we will mostly be adopted.
Good. So, the state is in agreement.
We are in agreement.
Call out the next part. So for the accused persons in E08 of 2025, you may be seated. wale ambao wameitwa kwa kesi ya Daniel kwenye Israeli naweza kutafuta mahali hapo kazini. For those that are remaining, please call it out.
Criminal number 70, 2025, State versus Peter Kinyanjui, alias Sarah Wanjiko.
Yes.
They should be here.
Peter
Peter and Sarah.
Please call them. Please call them. Please, let me.
Six constitutional questions.
This is a fresh matter.
This is a fresh matter.
And we are taking quorum in this one as well.
Thank you.
So, Mr. Mjiri is the new councillor that's coming into it, and Mr. Nguinga. Yes.
Yes, there's an element of serious persecution. The officials of the DCP, Democratic, a party in coalition with several others, including those represented by County Honorable Gachagua, Rigathi. That we are seeing state high-handedness. Whenever they hear the name Rigathi Gachagua. I'm going to invite Council Kibe Mungai to highlight the circumstances. The state feels is not towing their kind of political line. He is haunted and charged with terrorism. And I therefore want to invite Wakili Kide, because these two were even admitted as if they were Al-Qaeda criminals or Al-Shabaab and wanted to prison.
All the submissions that have been made by my learned colleagues so what we shall be submitting on is try to make some Your Honor, apart from the taking off from of the charges that are before this court, number one, in Kiambu, miscellaneous criminal application. One of the Sarah Wanjiko Vega was the second respondent. The Honorable Mr. Honorable Levi Kiberu, the Chief Magistrate of Kiambu, mention of Ms. Wanjiko Vega. Had made a similar application. That case in Roiro is criminal, miscellaneous criminal case number E465 of 2025. We shall make arrangements to furnish this court and the prosecution, if they do not have already, the said two rulings. In those two rulings, Your Honor, the summary is the offenses, particularly the particulars of the offenses facing those two accused persons are exactly the offenses that has precipitated their arraignment before this court. There are in both those two rulings your honorable honored colleagues, the chief magistrates, ruled that the prosecution had not tendered the required evidence or grounds to justify their further detention. Complying with the orders made by your honorable colleagues,